Good morning, ladies and gentlemen. Welcome to the campus of Georgetown University and to another in a series of conversations about religious liberty sponsored by the Religious Freedom Project of Georgetown's Berkeley Center for Religion, Peace, and World Affairs. I'm Tom Farr, the director of the Religious Freedom Project. In a moment, I'm going to invite my colleague and associate director, Tim Shah, to come up and introduce our keynote speakers. But first, I'd like to take just a moment and tell you a little bit about our project. In the event you don't know much about it, please take a look at the items that we've left on your chairs and pick up some of the literature that we've got for you. And by all means, go to our website if you'd like to know more about our project. But I'd just like to give you an overview of what we've been doing and where we plan to go. For the past 3 years, the project started in January of 2011, so we're nearing the end of our third year. And this is indeed a capstone conference, if you will, a celebration of our first 3 years, in which we're going to engage some of the issues that we have raised during the course of these years. The project operates on three basic premises which have arisen during the course of these years. And each of them, I would say, are hypotheses, really better than premises, because they're contested, and you'll see some contestation about them today. But let me tell you what they are, just to generate a little controversy, if I can. The first is that religious freedom is vital to the health of every person, whether they're religious or not, and to every society everywhere. And we define religious freedom in a very broad sense, really in a sense that I think doesn't exist anywhere in the world, but it's an ideal. It's not only the right to believe or not, and to worship or not, but it's the right to take belief into public life, into society, into culture, into political life, into civil society, into one's business, into the political life, the laws and the policies of a nation within due limits. So the first premise is that it's capacious and it's vital to individuals and societies. The second premise is that religious freedom is in crisis, global crisis. According to the Pew Research Center, 75% of the world's population lives in countries where religious freedom, in essence, does not exist. The way they put it is that there are very high or very high restrictions on religious freedom in countries where 75% of the world's population lives. Outside the West, this is increasingly manifested in a very alarming phenomenon of rising violent religious persecution against religious minorities, with Christians heading the list, but Muslims not far behind, and other religious minorities victimized as well. Inside the West, it seems, our hypothesis at least, is that religious freedom is itself, while religious persecution in any systemic sense is not there in Western Europe or the United States, and please God, never will be. Nevertheless, the value of religious freedom is declining. The belief in it, the understanding of it is consonant with our first hypothesis, that it's vital to individuals and societies. Certainly in Western Europe this is the case. Maybe it's more arguable in the United States, but it seems to us that religious freedom, once thought of as the first freedom of the American Constitution and the human soul, if you will, is in danger of becoming the 10th freedom, or the 50th freedom, or just special pleading by religious people. And the consequences of this, we think, are significant. But we will be debating those two premises. And the third is that the people who could do something about this are really not that interested in doing something about it, with honorable exceptions, many of whom are here in this room. In government circles and policymaker circles, people who could act on this are not that interested in acting, either because they don't believe there's any kind of crisis, or they don't believe that religious freedom is this kind of fundamental good that we have described it, or I've described it for you. The secular media, not terribly interested in this issue or in the global crisis, with exceptions, of course. Exceptions that I think tend to prove the rule, and even that part of the media that is a great teacher, for better or worse, for our young people and even for old geezers like me, the film and television industry seems to be utterly unaware, for the most part, with some exceptions of this issue. And then finally, the academy, wherefrom many of you derive, so to speak, or where you labor, is not terribly interested in this issue, either as a crisis or as a fundamental good. Now, those are all contestable hypotheses, but we spent the first 3 years sort of surveying the landscape. There are many projects that we've had. You can read about them on our website. You can watch videos. Let me just tell you about one that I think is symptomatic, or if you like, an icon of what I'm talking about, and that is we have undertaken to map the sources on religious freedom in the 5 major world religions. I think back when I had that bright idea and wonder if I should have my head examined. It was a huge project. We put up Christianity and Judaism. Islam comes next, and then Buddhism and Hinduism, hopefully all by the end of this year, but certainly early next. All of the sources, pro and con, that we can find, with some commentary by experts, on the way the world's 5 major religions, historically and in the present day, treat the issue of religious freedom. Very important mapping exercise for researchers and for the general public. And each of them, I think we've found, have had pros and cons with respect to religious freedom. So this is the kind of thing we've been doing for 3 years. And during the course of these 3 years, we have discerned some, along with help from others, particularly the Pew Research Center and Brian Grimm, who will be here, I think, tomorrow. We've discerned some tantalizing correlations that suggest where religious freedom is absent, other social, economic, political, intellectual goods are absent as well. And where there is more religious freedom, there are more of these goods. Now, of course, correlations don't prove causation, but that's what we're going to investigate with our new team of scholars, which we will be announcing later this year, beginning in January of 2014. We're going to investigate whether there are causal connections between religious freedom and things like the consolidation of democracy, things like economic growth, things like undermining religion-related violence, extremism, and terrorism, all of which, by the way, are subjects that we will debate here in the next 2 days. So we're delighted that you're here today. Please join us tomorrow as well. You can see the exciting lineup we have in the program. I won't go over all of these. I'll turn this over to Tim Shah now to introduce our keynote speakers. But before we do, just one final point. The great American Jesuit John Courtney Murray said a lot of interesting things, but among my favorites, that when we talk about disagreement, sometimes we really are just talking about confusion. And that's a failure. Confusion is a failure. True disagreement, principled disagreement, is an achievement of culture and of politics. And that's what we're about in the Religious Freedom Project. So again, thank you for being here. Tim, over to you.
Thank you very much, Tom Farr. As Tom said, I'm Timothy Shah, Associate Director of the Religious Freedom Project. Welcome to all of you, distinguished faculty from Georgetown, distinguished students, other guests. Thank you, all those of you who are already here who will be participating in our discussion today. It's a great pleasure and honor to welcome you. Thank you for being here. I'll just begin on the note on which Tom ended, that disagreement is an achievement. I think with the 2 distinguished speakers I'm about to introduce, we'll be achieving a lot of disagreement today. So I'm grateful for them, grateful for their being with us. But I should also add that these 2 distinguished scholars are also people whose graciousness and civility are most impressive. And I think we will have disagreement, but also great civility in our discussion today. It is indeed a distinct honor to introduce these 2 gentlemen. I'll be introducing our first keynote speaker, Nicholas Wolterstorff, now, and then after Professor Wolterstorff concludes his address, I'll introduce Professor Macedo. The discussion today that will be launched by Professors Wolterstorff and Macedo is really about the most fundamental issues with respect to religious freedom. What is religious freedom? What is religious freedom grounded in? What is its character as a moral, political, normative principle? How does it relate to other important rights and freedoms? What is its proper place in a liberal democracy? You can't get more fundamental and more basic than those questions. And all of those questions are on the table this morning and then into the afternoon. And I am deeply delighted and grateful that to begin our conversation, we are welcoming now Professor Nicholas Wolterstorff. Nicholas Wolterstorff is the Noah Porter Professor of Philosophy Emeritus at Yale University. He has also been a senior fellow at the Institute for Advanced Studies in Culture at the University of Virginia. He was active in teaching and research at Yale from 1989 to 2001. Prior to that, Professor Wolterstorff taught at Calvin College from 1959 until 1989. He's the author of an incredible range and number of books on a wide variety of topics, including his most recent books, The Mighty and the Almighty, An Essay in Political Theology, 2012, Justice in Love, 2011, Justice, Rights, and Wrongs, 2010. You see a pattern there. There's just about a book every year. Thomas Reid and the Story of Love, or rather, sorry, Thomas Reid and the Story of Epistemology, not the Story of Love. That's 2001. John Locke and the Ethics of Belief, 1996. There were books in between, but I didn't include all of them. Divine Discourse, Philosophical Reflections on the Claim that God Speaks, Until Justice and Peace Embrace, Reason Within the Bounds of Religion, and many, many other books. And I should also add that in the last 2 or 3 years, Cambridge University Press has published 4 volumes of Nicholas Wolterstorff's essays on a wide variety of topics, including epistemology, the philosophy of religion, moral philosophy, and political philosophy. Professor Wolterstorff was the president of the American Philosophical Association, Central Division. He also helped to found the Society of Christian Philosophers in 1978. It may be safe to say that one of Professor Wolterstorff's greatest achievements is that over a very long career, he helped to make academic philosophy safe for religious belief. The whole character of philosophy as an academic discipline has changed dramatically, in part as a consequence of Nicholas Wolterstorff's labors as a philosopher of religion. He is also a fellow of the American Academy of Arts and Sciences. He has given among the most prestigious lectures in the world, the Gifford Lectures at St. Andrews University. He's also given the Wilde Lectures at Oxford University, the Stone Lectures at Princeton Seminary, and the Taylor Lectures at Yale. Professor Wolterstorff received his PhD in philosophy from Harvard and his bachelor's degree from Calvin College. Please join me in welcoming Nicholas Wolterstorff, who will be talking about why everybody, everywhere, has a right to religious freedom.
Thank you very much, Tim. In his initial email to me about this colloquium, Tim Shah invited me to compose an essay on, and now I quote, "The foundations and character of religious freedom as a normative principle and the integral importance of religious liberty for liberal democracy," end of the quote. This is a daunting invitation to discuss the nature of religious freedom, the foundations of religious freedom, and the importance of religious freedom for liberal democracy. I can treat only a few aspects of the topic, and I hope that the ones that I've selected and what I have to say about them prove interesting and worthwhile for us to discuss. The paper that I prepared for this conference is much too long to be, well, it's not too long to be read, but it's too long for your patience. So I've done my best to get it down to, I think and hope, about an hour of reading. And I'm honored to have Professor Steve Macedo here as one of our prime political theorists, foremost political theorists, as my commentator. In a letter of 494 to the Emperor Anastasius, Pope Gelasius I declared that, quote, "Two there are, august emperor, by which this world is ruled, the consecrated authority of priests, and the royal power. In his tract of 2 years later, on the bond of anathema, Gelasius elaborated slightly that idea. He spoke of the church and empire each having a distinct sphere of competence, a distinct jurisdiction. Christ himself, says Gelasius, made a distinction between the two rules, assigning each its sphere of operation and its due respect. The emperor, he said, has governance over human or secular affairs. Those are his words. The pope, along with his bishops and priests, has governance over divine affairs, over spiritual activity. Once again, his terms. The doctrine that Gelasius articulated in these two passages came to be known as the two rules doctrine. From the time he wrote his letter until a century or so after the Protestant Reformation, this doctrine was almost always the framework employed in the West for discussing the relation of the state to religion and the church. The doctrine assumed that the church in a given area was unified, and that its membership for all practical purposes was identical with the body of those who were subjects of whatever was the government in that area. So what differentiated church and state was not a difference in whom they govern, but a difference in the activities that fall under their governance. This traditional separation of church and state was a crucial part of the context within which freedom of religion emerged in the West. There can be a certain degree of freedom of religion in a society that has a single unified governance structure, with authority over the lives of the subjects as a whole, including then their religion, but it will take a significantly different form from the form that it has taken in the West. It may, for example, take the form of the Ottoman millet system for non-Muslims. Though the separation of church and state presupposed by the two rules doctrine was an important part of the context within which freedom of religion emerged in the West, those who actually thought in terms of the doctrine seldom affirmed freedom of religion. The reason being that they almost always assumed a perfectionist view of the state, as they did of the church, indeed. State and church together aim at perfecting the people in virtue and piety. That assumption remained implicit in Gelasius' letter and tract, but in numerous later writings it was stated explicitly. From hundreds of passages that could be quoted on the matter, let me select one from John Calvin. Calvin says in one place, "Government does not merely see to it that men breathe, eat." Well, first he talks about the indispensability of separating, distinguishing the two rules. Then he goes on to say, "Government does not merely see to it that men breathe, eat, drink, and are kept warm, even though it surely embraces all these activities when it provides for their living together. It does not, I repeat, look to this only, but also prevents idolatry, sacrilege against God's name, blasphemies against his truth, and other public offenses against religion from arising and spreading among the people." That's John Calvin. In 1579, 20 years after the fourth and final edition of Calvin's Institutes, there appeared a tract with the title, in English translation, "A Discourse upon the Permission of Freedom of Religion," called Religionsvrede in the Netherlands. Though the author presents himself as Catholic, the predominance of scholarly opinion nowadays is that he was in fact the prominent Huguenot, Philip Duplessis Mornay. Here's what he says in one place. "I ask those who do not want to admit the two religions in this country, Catholic and Protestant, how they now intend to abolish one of them. It goes without saying that you cannot abolish any religious practice without using force and taking up arms and going to war against each other. If we intend to ruin the Protestants, we shall ruin ourselves, as the French did. The conclusion to be drawn from this is that it would be better to live in peace with them, rather than ruin ourselves by internal discord and carry on a hazardous, disastrous, long, and difficult war, or rather, a perpetual and impossible one." That's Philip Duplessis Mornay, or at least presumably. His argument was prescient. The impossibility of undoing the religious fission caused by the emergence of Protestantism forced Europeans to consider an alternative to the two rules doctrine and the perfectionist view of the state. Initially, they played with the idea of many Christendoms, each political unit enforcing its own preferred religion, be that Catholic or some version of Protestantism. The slogan became Cuius regio, eius religio. But within a relatively short time, even that proved impossible because diversity creeped into these mini-states. What then slowly took place among Western European political thinkers and actors was a fundamental rethinking of the task of the state and of the relation of the state to its citizens. Not just to the religion of its citizens, but to its citizens more generally. The idea of natural rights had been current ever since the 12th century among canon lawyers, and to a lesser extent among philosophers, theologians, and other theorists. That idea was now employed to replace the perfectionist idea of the state with what I think might be called appropriately the protectionist idea. The state is to protect citizens against violations of their natural rights by their fellow citizens, and citizens are in turn to be protected against violation of their natural rights by the state. The former of those two ideas, the idea of the state as a rights-protecting institution, received canonical formulation in the U.S. Declaration of Independence. We hold these truths to be self-evident, that all men, human beings, are endowed by their Creator with certain inalienable rights, that among these are life, liberty, and the pursuit of happiness, and that to secure these rights, governments are instituted among men. The latter of the two ideas, the idea of the state as a rights-honoring institution, received canonical expression in the first 10 amendments to the U.S. Constitution, known as the Bill of Rights, the aim of which was declared to be, quote, to prevent misconstruction or abuse of the federal government's powers. You all know the famous First Amendment, Congress shall make no law respecting an established, or part of it, no law respecting an establishment of religion or prohibiting the free exercise thereof. This represents a stunning rejection of the perfectionism that went hand in hand with the two rules doctrine. Instead of the state being enjoined in conjunction with the church to seek the perfection of its citizens with respect to morality and religion, this first article protects the people against the state with respect to the exercise of their religion. So let me summarize what I've said so far. The religion clauses of the U.S. Bill of Rights declare that citizens are to have the civil right to freedom of religious exercise and to freedom from non-establishment, and to freedom from establishment. The emergence of that conviction was the result of the contingent confluence of three factors, namely, the traditional understanding of church and state as two distinct institutions with distinct jurisdictions. Second, the breakup of the religious unity of Europe and the subsequent abandonment of the perfectionist view of the state. And third, the employment of the idea of natural rights, an idea long common among canon lawyers, to think of the state as a rights-protecting and rights-honoring institution with religious freedom and non-establishment prominent among the natural rights to be honored. With those introductory comments, let me now turn to this daunting assignment that Tim Shah gave me, beginning with the nature of religious freedom. Let me approach the topic from a somewhat oblique angle. In modern liberal democracies, Protestants and Catholics are not killing each other, as they were when the author of a discourse upon the permission of freedom of religion wrote his tract. But the relation of the state to the religions of its citizens remains the site of controversy in our American liberal democracy, as it does in all others. So the question I'd like to pursue for a while is this. What is it about religion, and what is it about the liberal democratic state that results in religion continuing to pose quandaries to the state? Those quandaries and the state's handling of them, in turn causing controversies in the public. And to get at the issues, I'm going to use the United States as my example. Considerations of space require me to focus exclusively on free exercise and to say next to nothing about non-establishment. That's unfortunate, I think, since the form that the civil right to religious freedom has taken in the U.S. is due in good measure to its intertwinement with the proscription of establishment. Now, some of the quandaries presented by religion to the liberal democratic state are definitional controversies. Is this act on the part of these citizens an exercise of their religion, or is it not? If it is, does this law or policy on the part of government constitute an infringement on their free exercise of their religion? Actually, the First Amendment speaks of prohibiting rather than infringing on. And sometimes those definitional questions will have no clear answer, with the result that reasonable people will disagree on the answer, or you and I, if we're not forced to give an answer, would prefer not giving an answer. Just saying, well, I don't know, sort of like a religion, sort of not like a religion. In her contribution to an online forum on the politics of religious freedom sponsored by the blog The Eminent Frame, Winifred Fuller-Sullivan wrote the following: "It is a commonplace in the academic study of religion to observe that the word religion is manifestly conditioned by the history of its use, and that it is deeply problematic, epistemologically and politically, to generalize across the very wide range of human cultural goings-on that are now included in this capacious term. It is also common to note that the very specific difficulty of definition that faces interpreters and enforcers of legal instruments purporting to protect and regulate the freedom of religion." End of quote. I understand Sullivan to be suggesting, though not quite saying, that the term religion is too vague for the larger term freedom of religion to pick out anything definite, and that we should just cease and desist from talking about freedom of religion. Now, it's true, of course, that the term religion is not a natural kind term. It's more like the term game that Wittgenstein discussed at length in Philosophical Investigations. Games, he argued, are united not by some shared essence, but by family resemblances. The term religio was used already by the ancient Romans to group together certain activities whose similarities they found it important for the purposes at hand to take note of. And the same is true for our term, English term, religion. Though a much used term in our English vocabulary, obviously, Sullivan holds, nonetheless, that the term is deeply problematic because it is manifestly conditioned by the history of its use and because it generalizes across a very wide range of human cultural goings-on. Others argue that it's problematic because there are borderline cases in which we're just not sure whether to call something a religion or not. I don't find these arguments for the conclusion that the term religion is deeply problematic compelling. And in particular, I'm not persuaded by the argument that we should give up talking about freedom of religion because the concept of religion is too problematic. Here's why. All terms are conditioned by the history of their use, and many of them generalize across a wide range of phenomena. The term heavenly body generalizes across a very wide range of phenomena. That doesn't make it particularly problematic. And as to the fact that there are borderline cases in which we're just not sure whether to apply the term religion or not, many, if not most, terms are like that. The term reigning, for example. That does not make such terms too problematic to be of any use. I think the term reigning is very useful, though there will be misty situations in which you're not sure whether to call it reign or not. And as to jurisprudence concerning the free exercise clause, the issue to consider here is whether there are so many cases in which it's not clear whether or not something is a religion that the term has just become useless for purposes of the law. I judge that that is definitely not the case. In a great many cases, it's perfectly obvious that something is a religion, and perfectly obvious that it's being exercised. Such cases don't find their way into the courts for the reason that they are obvious. But now let me go on to make a different point. By no means are all the quandaries and controversies concerning the civil right of Americans to freedom of religion definitional. There may be little doubt that some law or policy on the part of the government is an example of infringing on someone's freedom, of someone's exercise of his or her religion. Nonetheless, it may be a point of controversy as to whether or not it is legally permissible. Let's see why this is. Most of the religions present in Western liberal democracies are exercised by adherents of the religion participating in communal rituals and engaging in acts of private devotion. One would think that such forms of exercise would pose few quandaries to the liberal democratic state. It's usually easy to see that these activities count as an exercise of the religion in question, and usually it's easy to tell whether or not some law or policy infringes on their free exercise. But things prove not as simple as one might have expected. Here's why. The religion clauses in the first article of the U.S. Bill of Rights had the rhetorical flavor of articulating absolutes. Congress shall make no law respecting an establishment of religion, and no law prohibiting the free exercise thereof. But that's not how the courts have interpreted these clauses. They have interpreted them as articulating what philosophers call prima facie rather than absolute, ultima facie, prohibitions on governmental action. Or to view it from the other end, as articulating prima facie rights of citizens vis-a-vis the government, rather than absolute ultima facie rights. Whether or not a person's prima facie right to free exercise is in fact outweighed in a given case by other rights is very much a judgment call on the part of the courts. These judgment calls are invariably controversial, and liberal democracies differ considerably in how they make them. So to know what the American government is actually prohibited from doing by the two religion clauses, and hence to know what our civil right to religious freedom actually comes to, one cannot just exegete the language of the clauses. One has to look at the long and complex series of often convoluted court decisions as to which infringements on free exercise and which violations of no establishment are permissible, because there are other greater rights at stake, and which are not. The quandaries posed to the government by the communal rituals and private devotions of the religions present in society pale, however, before the quandaries posed by the fact that seldom is the exercise of a religion limited to such ritualistic devotional activities. Almost always the exercise of a religion spreads out into everyday life, sometimes in surprising ways. In order to exercise their religion as they believe it should be exercised, groups establish faith-based hospitals, adoption agencies, educational institutions, relief agencies, development agencies, housing agencies, social justice organizations, and so forth. They wear special garb in public. They set up statues on which are carved 10 Commandments, on and on and on and on. I think it's easy to see that such forms of religious exercise will regularly pose quandaries to the government. Suppose the government decides that recitation by school children of the Pledge of Allegiance enhances national unity, and that such unity is very important. Is it then permitted to require recitation of the pledge by all school children, even though reciting the pledge would violate the religious convictions of some people, for example, Jehovah's Witnesses? When the U.S. Supreme Court was faced with that particular question pertaining to Jehovah's Witnesses, it determined that it was not permissible to require them to recite the Pledge of Allegiance. Of course, we don't have to dredge the past for cases of this sort. The current debate over the restrictions on free exercise of religion implicit in the Affordable Care Act in its present form is another example of the point. We do not yet know what the courts will say on this matter. Now, one of the lessons I want to draw from these observations is that the precise contour of the civil right of Americans to freedom of religion depends on how the courts resolve disputes over borderline applications of the terms exercise and religion and free exercise. And secondly, on how they resolve disputes over when the prima facie right to free exercise is outweighed by other more weighty rights of public safety, order, health, and so forth. A second lesson I wish to draw is that we must expect that the precise contour of the civil right to freedom of religion will differ from one liberal democracy to another. And in fact, the contour of the civil right to freedom of religion in the United States is significantly different from the contour of the civil right to freedom of religion in, say, France, present-day France. So what follows? Does it follow that there is the present-day American civil right to freedom of religion, the present-day French civil right to freedom of religion, and so forth, and that that's the end of the matter? Does it follow that there is no such thing as the natural right to free exercise of one's religion? When the U.S. Congress passed the International Religious Freedom Act in 1998, requiring the State Department to report annually on the state of religious freedom around the world, and in certain ways to promote religious freedom, was the Congress at bottom doing nothing more than engaging in an attempt at cultural domination? Was the passage of the act nothing but power masquerading as high principle? Now, I understand it to be the view of some of those who posted contributions to the online forum that I mentioned on the politics of religious freedom sponsored by the Eminent Frame, that it's their view that, of some of them, that these things do follow. In a draft of a book that he's working on and that he let me see, Dan Philpott, is Dan here yet? Well, he will be, right? In a draft of a book that he's working on that he kindly let me see, Dan summarizes the position of these bloggers as follows, quote, "Far from being a universally valid principle, religious freedom is the product and the agenda of one culture in one historical period, the modern West. And in the West it should stay and be kept under strict surveillance." So let's assume that Philpott's interpretation is correct, that there are what might be called, what he calls the new critics of freedom of religion, and that they affirm the position that Philpott attributes to them. I hold that this position does not follow from the fact that the particular contour of the civil right to religious freedom differs from society to society and from time to time within a given society. In denying that religious freedom is a universally valid principle, the new critics presumably mean to deny that there's a natural right to religious freedom. But from the fact that certain persons have a civil right to so-and-so, nothing follows one way or another as to whether or not they also have a natural right to so-and-so. And so too, from the fact that certain persons don't have a civil right to so-and-so, nothing follows one way or the other as to whether or not they also do not have a natural right to so-and-so. Now, a natural response to this observation about the looseness between civil rights and natural rights is that, though it's formally correct, it's irrelevant to the topic at hand. Here's the thought. If there is no such thing as the civil right to freedom of religion, only the civil right in 2013 of Americans to freedom of religion, the civil right in 1913 of Americans to freedom of religion, the civil right in 2013 of the French to freedom of religion, and so forth, how can these diverse civil rights all be grounded in something referred to as the natural right to freedom of religion? Well, assume for the moment that there is a natural right to freedom of religion. My answer to the question posed is that the various contours of the civil right to freedom of religion are all to be understood as positivizings. To use a term that used to be fairly common, but I think has almost fallen out of political theory nowadays, positivizings of the natural right to freedom of religion. Each particular contour of the civil right to freedom of religion is the articulated inscription into law, the positivizing of the natural right to freedom of religion. And there's nothing peculiar here about religion. The points made about freedom of religion also apply to freedom of speech. The contour of the civil right of Americans to free speech is slightly different in 2013 from what it was in 1913. And it's pretty significantly different from that of the right of the English to free speech in 2013. Assuming that there is a natural right to free speech, these distinct contours of the civil right to free speech are all to be seen as positivizings of the natural right. I have emphasized that the civil right of Americans to religious freedom arose out of a unique confluence of historical factors. From this, it does not follow that the civil right to religious freedom cannot emerge from a very different set of historical factors. Witness the old Ottoman millet system. I have likewise emphasized that the civil right of Americans to religious freedom has its own unique contours. From this, it does not follow that when I, an American, urge some other government to grant religious freedom to its citizens, I am implicitly urging them to imitate the American contour. I may be doing that, and if so, I am rightly to be charged with an attempt at cultural imperialism. But rather than urging them to imitate the American contour, I may simply be urging them to positivize the natural right to religious freedom in whatever way is best for their particular society. And now we get to what Tim Shah, in the assignment he gave me, called the foundations of religious freedom as a normative principle. In my text, I say here that I think it will be helpful if, before I present my own proposal, we take note of those that were in the air at the time of the American founding. I'm going to skip over almost everything I say on that topic and simply quote, well, in 1776-77, all of the newly formed U.S. states formed constitutions. They had to. In all of them, there's a guarantee of religious freedom. All of them are strikingly similar with respect to, with the exception of that of New York State, which says some things about wicked priests and being delivered from the hands of wicked priests and so forth. What's far more characteristic is, and actually more elaborate than any of the others, is the Pennsylvania Constitution. Let me read a few sentences from it. It says this, that all men have here's why they think there has to be a civil right to religious freedom, that all men have a natural and unalienable right to worship Almighty God according to the dictates of their own consciences and understanding, and that no man ought, or of right, can be compelled to attend any religious worship, or erect or support any place of worship, or maintain any ministry, contrary to or against his own free will and consent. Nor can any man who acknowledges the being of God be justly deprived or abridged of any civil right as a citizen on account of his religious sentiments or peculiar mode of religious worship. The Pennsylvania Constitution. But what it is saying quite elaborately is said or strongly hinted at in all the others, with the exception, as I say, of New York. Now, in our day and age, we who believe that the civil right to religious freedom is of fundamental importance can obviously not just recite these words from the Pennsylvania Constitution in defense of our conviction. Many of our fellow citizens hold that there are no natural rights, only rights bestowed by laws, social practices, and speech actions. Of those who agree that there are natural rights, many hold that there is no God, Almighty or otherwise. So, of course, there's no natural right to worship Almighty God. And some of those who hold that there is no God regard religion as a menacing relic of irrational, primitive ways of thinking, and see no more reason to think that there's a natural right to the free exercise of one's religion than there is, say, to the practice of quack medicine. Yet others hold that it's a mistake to single out religion for special treatment. The right to religious belief should be treated as a species of the right to liberty of conscience, and the right to religious exercise should be treated as a species, say, of the right to freedom of speech. So we can't just repeat what the founder said. I come now to the hard part, namely my own attempt to defend the claim that there is a natural right to free exercise of one's religion. Looking back over previous writings of mine, I noticed, to my surprise, that this is something I have never hitherto attempted. So almost certainly my formulation of the argument will be flawed, and maybe the argument as such is flawed. I'm going to trust you and my commentator to point that out if it is in fact the case. Let me say at the outset that to establish that there is a natural right to religious freedom, it will not be sufficient to argue, as does John Finnis, for example, in Natural Law and Natural Rights, that religion is a great good. For one thing, if religion is just a great good, then it's possible that situations would arise in which society judges that freedom of religion is to be sacrificed in terms of some yet greater good, national unity, for example, characteristic. More important for our purposes here, however, is the fact that, as I see it, one cannot pull the rabbit of rights out of a hat that contains only life goods. I think it would be a really great good in my life if the Rijksmuseum in Amsterdam gave me that glorious painting by Rembrandt titled The Jewish Bride to hang on my living room wall, along with a round-the-clock security force to stand guard. But I don't have a right to their doing that. The Rijksmuseum is not wronging me by not having given me that painting. On the other hand, the brusque reply to my inquiry by the receptionist in the health service is a small harm in my life. Nonetheless, I have a right to her not answering me in that snarky way. To account for why it is that we have a right to certain life goods and not to others, we have to introduce into the picture something other than life goods. I hold, as do others, that that something is the worth or dignity of the rights holder. Worth or dignity of the rights holder. You have a right to the life good of my treating you a certain way. Just in case were I not to treat you that way, I would not treat you as befits your worth or dignity. On this occasion, let me assume, then, without argument, that rights are indeed grounded in the worth or dignity of the rights holder. And let me also assume, without argument, that there are natural rights, rights not conferred on rights holders by laws, social practices, or speech actions. I know, of course, that both of these assumptions are highly controversial. I've defended them elsewhere. If I did so here, we wouldn't finish before 2 o'clock. And I invite those of you who are dubious about these two assumptions to adopt a sort of hypothetical attitude toward the argument that follows. Like this: suppose there are natural rights, and suppose that they are grounded in the worth or dignity of the rights bearer. What reason might there be for holding that among our natural rights is a natural right to free exercise of one's religion? For my purposes here, I need some account of religion. I could devise my own account, but I think for these purposes it's better for me to refer you to an interesting recent account by Thomas Nagel, the Columbia philosopher Thomas Nagel, an account of what he calls the religious temperament in his essay, Secular Philosophy and the Religious Temperament. The religious temperament, says Nagel, is the belief, quote, that there is some kind of all-encompassing mind or spiritual principle, in addition to the minds of Nagel is himself not a theist, I should say. In addition to the minds of individual human beings and other creatures, and that this mind or spirit is the foundation of the existence of the universe, of the natural order, of value, and of our existence, nature, and purpose. The religious temperament, to put it in other words, is the belief in such a conception of the universe, and the incorporation of that belief into one's conception of oneself and one's life. The religious temperament addresses the question of how an human individual can live in harmony with the universe. In Nagel's explanation of the religious temperament, belief is prominent, as you may have noticed. We can debate whether it should have the prominence that Nagel gives it. But more important for my purposes here is that, as I see it, a person's religion should not be identified with her religious temperament. Her religion is her religious temperament, along with her way of giving expression to that temperament and her way of living, including her religious practices. A person's religion is her particular way of living, I quote Nagel, in harmony with the universe. I judge that everything covered by this account would naturally be called a religion. Whether it's also the case that everything that would naturally be called a religion is covered by this account is perhaps less clear, but it won't make any difference to my argument. Now, most present-day thinkers who hold both that there are natural rights and that these are grounded in the worth or dignity of those who possess the rights are of the view that what imparts to the rights holder the relevant dignity is the capacity for rational agency. That is, the capacity to act for reasons and not just out of causes. Some hold the more specific view that the dignity in question is grounded in the capacity for normative agency. That is, in the capacity to perform an action for the reason that one judges it to be a good or obligatory thing for one to do. Now, I think that capacity imparts to us great dignity, so I agree with that. But I've argued in a number of places that this account of the dignity that grounds natural rights is inadequate. Obviously, it does not account for the dignity of those human beings who are not capable of functioning as persons and who accordingly lack the capacity for normative agency. Infants, for example, and those in a permanent coma or suffering from the final stages of Alzheimer's disease. More relevant to our purposes here, however, it seems to me that it also fails to account for a good many of the rights possessed by those who are capable of functioning as persons. For example, it does not account for the right not to have one's privacy invaded. Even if the person who invades one's privacy does nothing with what he learns other than enjoy it at home, thus in no way impairing one's agency, one's autonomy, one has nonetheless, in my view, been wronged. So, rational and normative agency do indeed give to those creatures who possess such agency great worth and dignity. But what is indicated by the examples I have given, along with a good many others that I could give, is that what gives to human beings the worth and dignity on which human rights supervene has to be more than just the capacity for rational and normative agency. To account for natural rights, we need a richer account of what it is to be a human person. And now here is not the place to present an account of the human person rich enough to account for the dignity that grounds the full panoply of natural rights. Let me confine myself to singling out those aspects of the human person, in addition to the capacities for rational and normative agency, that seem to me directly relevant to the natural right to free exercise of one's religion. So here goes. Two of them. First, to be a human person is to have the capacity to interpret reality and one's place therein. Some of these interpretations happen naturally, as in introspection and perception. I just naturally interpret what is presented to me as the sun rising over the horizon. In our capacity for such interpretations, we are similar to some of the animals. But to be a human person is also to have the capacity for interpretations that are optional, not given with our nature, and that go far beyond perceptual and introspective interpretation. We, human beings, interpret what is happening as the gods being angry, or as the far-flung effects of the Big Bang, or as the dire effects of libertarianism spreading among the populace, and so forth. Interpretations such as these go vastly beyond perceptual and introspective interpretations, and are optional in the sense that some human beings interpret reality in that way and some don't. As for myself, I cannot imagine what it would be like not to have the capacity for such interpretations of reality and of my place therein. It is a pervasive and fundamental part of my life. So pervasive and fundamental that I normally don't take any note of it. I take it for granted. But when I do stand back and take note of it, take note of the fact that we human beings are able to interpret physical reality as the effects of the Big Bang, I find this capacity amazing, remarkable. If any of the non-human animals have this capacity or something like it, they have it to only a minimal degree. And second, to be a full-fledged human person is to have the capacity to form what I shall call a valorized identity. What I mean by the valorized identity of a person consists of the relative importance that the person assigns to the states and events in her own life, to her various beliefs, her various commitments, her plans for action, her attachments to persons, animals, objects, her memories, and so forth. We say such things as, "This commitment is more important to me than any other. I cannot imagine giving it up. It is fundamental to who I am." In saying such a thing, one is verbalizing one aspect of one's valorized identity. One's valorized identity, as I'm thinking of it here, consists not of the importance one assigns to things outside oneself, though we do that too, of course, but to the various states and events in one's own life, constituting then one's identity. As for myself, I cannot imagine what it would be like not to have the capacity to form my own valorized identity. It too is a pervasive and fundamental part of my life, so much so that I rarely take note of it. I take it for granted. But when I do stand back and take note of it, I find it remarkable, amazing. If any of the non-human animals have this capacity, or something like it, they have it only to a minimal degree. I've stressed that these two capacities are amazing. But not only are human persons amazing and remarkable on account of possessing these capacities, plus those for rational and normative agency, they have great worth on account of possessing these capacities. On account of possessing these capacities, human persons are precious. They have multifaceted dignity. They are to be prized. Something of great worth is lost when these capacities are destroyed or diminished or disappear. Now, religions represent a remarkable exercise of these two capacities, along, of course, with the capacities for rational and normative agency. To see this, recall Nagel's description of the religious temperament. The religious temperament is the belief that there is some kind of all-encompassing mind or spiritual principle in addition to the minds of individual human beings and other creatures, and that this mind or spirit is the foundation of the existence of the universe, of the natural order, of value, and of our existence, nature, and purpose. The religious temperament is the belief in such a conception of the universe and the incorporation of that belief into one's conception of oneself and one's life. It's obvious that religion, so understood, is a manifestation of the two capacities I identified, along, of course, with those of rational and moral agency. A person's belief includes the belief, Nagel's description, that there is some kind of all-encompassing mind or spirit that is the foundation of the existence of the universe, of value, and of our own existence, nature, and purpose. Such a belief is obviously a manifestation of the remarkable and precious capacity for interpretation that I took note of. A person's religion is not just that belief, however, but includes, along with the belief, a way of giving expression to that belief in life and practice. And that will perforce be an exercise of the person's capacity for forming a valorized identity. So if one holds, as I do, that these two remarkable capacities gives to those creatures who possess them great worth, as do the capacities for rational and normative agency, then one will have a prima facie reason to refrain from stifling or restraining the exercise of these capacities and for resisting the attempt of others to do so. Now consider Richard Dawkins, Daniel Dennett, and others of their sort. People who embrace a secular alternative to religion that is, in fact, a manifestation of the same capacities of which religion is a manifestation, and to which they are as ardently attached as is any religious adherent to his or her religion. Probably more ardently attached than most religious people to their religion. The argument I've given leads to the conclusion that their embrace and exercise of that alternative should receive the same protection in law as does the free exercise of religion. I dare say that some will regard this implication as a reductio ad absurdum of my argument. I regard it as an implication that should be embraced. Making it illegal for Dennett to express and practice his secular alternative to religion would be a violation of his personhood, in the same way that making it illegal for me to express and practice my religion would be a violation of my personhood. Now a new and penultimate topic. Earlier I noted that the religious fracturing of Europe and the subsequent wars of religion forced the emergence in Europe of a new form of state, liberal democracy. The old familiar perfectionist form of state was just no longer possible. But not only did the fracturing of religion require a new kind of state, the new kind of state required a certain kind of religion. There had to be mutual accommodation. Accommodation of the state to religion and accommodation of religion to the state. Richard Rorty remarks in one place that, quote, the happy Jeffersonian compromise that the Enlightenment reached with the religious consists in privatizing religion, keeping it out of the public sphere. Now, that seems to me clearly not correct. Religion in liberal democracies has not, in general, been privatized, nor I take it has that been the agreement. But the larger point, that certain forms of religion are incompatible with the liberal democratic state, is undeniable. Were I to develop this point, I would look at the version of Islam that Sayyid Qutb propounded in the commentary that he wrote on the Quran titled In the Shade of the Quran. In good measure, Qutb shaped his view of Islam in conscious opposition to what he called this hideous schizophrenia between religion and life that he saw as characteristic of Western liberal democracies and that he experienced when he was here in the States in the 60s at the University of Colorado. Whether he would have experienced that schizophrenia if he'd been at Georgetown University is a nice question. But rather than developing that point, let me bring this talk to a close by calling attention to the presence in liberal democracies of voices that find the structural accommodations of religion to liberal democracy inadequate. These voices hold that religions endanger peace, justice, and the stability of liberal democracy, even if they have accommodated themselves to the structural principles of liberal democracy. And even if religious people do accept those infringements on the free exercise of religion that the courts judge permissible. These voices call for a further shaping up on the part of religion. So here goes. John Rawls, let me order these voices, starting with those that call for the most limited form of shaping up, and concluding with those that call for the most radical form. John Rawls and his followers hold that it's acceptable for citizens to employ reasons drawn from their own particular religion when debating significant public issues in public and when making decisions on those issues. But if they do, they must stand ready to offer reasons for the positions they favor that are drawn from what Rawls calls public reason. What exactly Rawls means by public reason is the subject of a vast literature that I'm not going to get into. I'm going to assume that you've got a good enough idea of what it is. Now, in all liberal democratic societies, there are religious people who affirm liberal democracy, but are not in the habit of debating and deciding political issues on the basis of reasons drawn from public reason. It's their habit to debate and decide political issues on the basis of reasons drawn from their own particular religion. And for some, this isn't just a habit. They believe that this is what they ought to do. So satisfying the Rawlsian injunction requires of them that they shape up by acquiring the ability and the willingness to debate and decide significant political issues on the basis of reasons drawn from public reason. Richard Rorty, as I've already hinted, urges a more stringent form of shaping up. In an essay of his, he asserts that ecclesiastical institutions, despite all, I quote him, despite all the good they do, despite all the comfort they provide to those in need or in despair, are dangerous to the health of democratic societies, so that it would be best for them, religious institutions, eventually to wither away. The dangers posed to democracy by institutionalized religion are particularly evident, he says, in present-day United States, where Christian fundamentalists whose support has become indispensable to right-wing American politicians are undermining the secularist Jeffersonian tradition in American culture. And the danger can only be averted by religion shaping up so that it becomes entirely personal and private. The religion of one's inner life can be of whatever form and intensity one wishes, no harm there. It's when religion leaves the sanctuary of the inner life and tries to shape the state and other social institutions that it endangers liberal democracy. Third, in John Hick and his allies in the discussion on religious pluralism, one finds a yet more radical proposal for the shaping up of religion. In his well-known book, Interpretation of Religion, John Hick urges that particularist religions, Christianity, Judaism, Islam, and so forth, rather than learning to live within bounds, should reinterpret their particularisms so that they are no longer exclusivist religions. Hick holds that any axial or post-axial religion that does not accord equal religious significance to all other such religions perforce harbors within itself the threat of coercion and violence. Just one example, as long as Christianity harbors a supersessionist attitude toward Judaism, there can be no abiding peace between these two religions. The solution is for each axial and post-axial religion to regard all such religions as just alternative ways of engaging the real, with none of them giving us the literal truth of the matter, and for each to concede that all are equally successful in achieving salvation for their adherents. A fourth and yet more radical version of the line of thought that I am delineating says that particular religion, whatever its form, content, or self-understanding, particular religion poses a danger to the liberal democratic society. It must wither away. Rather than shaping up by living within the bounds of public reason, by living within the bounds of the inner life, or by reinterpreting itself so that it's no longer exclusivist, it must transmute itself into non-particularist religion. And this is what Jacques Derrida proposed in some of his late writings. In his reflections on the return of religion that he sensed to be occurring at the time he wrote these essays, Derrida undertook a program of analysis for the forms of evil perpetrated in the four corners of the world in the name of religion. His analysis led him to the conclusion that violence is the inevitable consequence of what he called determinate religion. The solution is for determinate religion to be transmuted into religion without religion. Take an example. A structural feature typical of the religions that interested Derrida is the messianic structure. Adherents of the religion look forward to a day when justice and peace shall reign. Religion without religion would then be religion in which all determinate content has been abstracted from such messianic anticipation, leaving only the pure messianic structure. Such religion would be structural messianism, messianism without content, or simply the messianic. A condition of the elimination of political violence is the transmutation of present-day religions into a religion in which messianism is purely structural. The line of thought that I've been highlighting runs deep in the mentality of modernity. Religions pose a danger to peace, justice, and the stability of the liberal democratic polity. They must accordingly shape up in ways that go beyond what is required for living within the structure of liberal democracy, and beyond acceptance of those infringements on free exercise that the courts judge permissible. My response is that I see no prospect whatsoever of religion in general disappearing. nor of all determinate religions disappearing to be replaced by some religion of pure structure, nor of all particular and determinate religions reinterpreting themselves so that they are no longer exclusivist, nor of all particular and determinate religions becoming privatized. That religion is often a danger to peace, justice, and the stability of our liberal democratic society, and others as well, is beyond doubt. But I think we have no choice but to deal with those dangers in ad hoc fashion when and where they arise. There is no prospect, so far as I can see, of averting them all in advance. In the above list of what I saw no prospect of happening, I did not mention that I saw no prospect of all adherents of particular and determinate religions appealing to Rawlsian public reason in debating and deciding political issues. One of the best statements that I know of the present state of the public reason debate is a recent essay by my commentator Steve Macedo titled Why Public Reason? Citizens' Reasons and the Constitution of the Public Sphere. It's an excellent essay. In his opening paragraph in the article, Macedo observes that among the objections to the public reason position launched by critics is, in a deeply religious and pluralist society, the proposed Rawlsian norm seems unlikely to be accepted. As Macedo well knows, I am one of the critics of the public reason proposal, and I do indeed see no chance of citizens in general conforming to the Rawlsian norm. But rather than pressing that point further, I want to close this talk by posing an objection to the public reason proposal that flows directly from my defense of there being a natural right to religious freedom. It's an objection that I've raised in previous writings, and in the literature on these matters, it has come to be called the integralist objection. It's not a name that I gave to it, but it's pretty good. So consider a religious person of the following sort. He favors liberal democracy. He endorses, to quote Rawls, the idea of citizens as free and equal citizens, and of society as a fair system of cooperation over time. He has somewhat different reasons than Rawls does as to the implications of those ideas, but he affirms the ideas as stated. He's willing to offer reasons for the policies he favors, and he's willing to listen with open mind to criticisms of those reasons coming from others and to alternative reasons. As to the reasons he offers, he regards himself as obligated to ground his political reflections and arguments on the resources of his own religion, plus relevant non-normative factual knowledge, and on those resources alone, when these speak to the matter at hand. The conviction that he is so obligated belongs to his religion. He sees fidelity to God as requiring this of him. To use Rawls's language, a component in his comprehensive religious doctrine is that he use the resources of his comprehensive doctrine, and only those resources, in deliberating, debating, and voting on some important political issue. Given the understanding of religion that I adopted from Nagel, an understanding according to which religion is a comprehensive interpretation of reality rather than some sort of add-on, I think we should not be surprised that there would turn up religious people of this sort. Now, the person I'm imagining knows that lots of people in his society, including a good many of his co-religionists, regard him as deeply misguided. A lot of them call him a fundamentalist. Whenever people go beyond referring to him with this pejorative language and give him a reason for thinking that he's deeply misguided, he listens carefully and with open mind to what they say. So far, he's not been convinced by them. Having listened carefully and openly to their objections, without being convinced, he's now entitled to his convictions. There's nothing more that can be asked of him. It cannot be asked of him that he decide to change his views. Nobody can do that. Beliefs are not the product of a volition. Let's give this sort of religious person a name. Let's call him a Barthian, lowercase b. Because I think it's probably a view that the actual Karl Barth would adopt. But lower b, okay? The attitude of the Barthian toward employing public reason in thinking and talking about political issues is very much like the attitude of the Kantian toward thinking about moral and political issues along, say, utilitarian lines. The Kantian regards that way of thinking as deeply misguided. So he refuses himself to think in those terms about moral and political issues, though he's willing to get inside the head of the utilitarian and try to see if he can argue on utilitarian ground, but that's not what leads him to his own convictions. Now, I think the Barthian should feel free to think and argue as he believes he should. In doing so, he is exercising his natural right to religious freedom. Of course, nobody proposes that there be a law forbidding him from acting thus. Everybody agrees that he should have the civil right to act this way. But beyond that, I fail to see that he is in any way violating the spirit, the ethos, the governing idea, to use Hegelian language, of liberal democracy. That's my view. But what does public reason liberalism of the Rawlsian variety say about this Barthian? Well, the answer to that question proves to be less obvious than one would have thought. In fact, the answer that I think the Rawlsian should give has an air of paradox about it. Nowhere that I know of does Rawls consider the sort of religious citizen that I have invited the reader to imagine. So far as I can tell, Rawls just assumes that no reasonable comprehensive doctrine, in his sense of reasonable, would include the conviction that one should reason about political issues only in terms of one's comprehensive doctrine. But suppose a Rawlsian were asked the question, what should a religious citizen of the Barthian sort do? What would a Rawlsian say? Would he say that if the Barthian were unable or unwilling to renounce that troublesome component in his comprehensive doctrine, he should refrain from advocating in public for political positions and refrain from voting, that he should just opt out of the political process? Well, maybe some Rawlsians would say this, but given the Rawlsian position as a whole, I don't think that that's what they should say. Now, the should in the imperative proposed by public reason liberals, you should appeal to public reason or stand ready to do so. The should is a prima facie should. Public reason liberals recognize that citizens may find themselves in situations in which they see themselves as having, and do in fact have, other prima facie obligations that conflict with and outweigh their obligation to conform to the public reason imperative. So I think what the public reason liberal should say to the Barthian is that since he regards himself as having an overriding duty to God to employ only the resources of his own religion in thinking and deciding about political issues, plus whatever non-normative factual knowledge is relevant, and since he's entitled to that conviction, having listened to objections, that's what he should do. He should not follow the public reason imperative. Perhaps others should, but he should not. Given his comprehensive doctrine, it is his ultima facie duty not to conform to the public reason imperative, unless his comprehensive doctrine has nothing to say on the matter at hand. I think public reason liberalism leaves the Barthian free to use religious reasons, and only religious reasons, in public debate on political issues and in deciding how to vote. Thank you.
Thank you very much, Professor Wolterstorff. And now the disagreement that we're hoping to achieve. It's my pleasure now to introduce Professor Stephen Macedo, who is the Lawrence S. Rockefeller Professor of Politics at Princeton and a former director of Princeton's University Center for Human Values. He's the founding director of Princeton's program in law and public affairs, and he chaired the Princeton Project on Universal Jurisdiction. He was the vice president of the American Political Science Association and the first chair of its Standing Committee on Civic Education and Engagement. He's authored numerous major books in political theory, including Diversity and Distrust, Civic Education in a Multicultural Democracy, Liberal Virtues, Citizenship, Virtue, and Community in Liberal Constitutionalism, and other books. He's also editor of several major works, including Democracy at Risk, How Political Choices Undermine Citizen Participation and What We Can Do About It, Universal Jurisdiction, National Courts and the Prosecution of Serious Crimes Under International Law, that's 2004, Child, Family, and State, 2003, and Deliberative Politics, Essays on Democracy and Disagreement. His current scholarship focuses on a wide range of issues, social justice and immigration, democracy and international institutions, constitutional democracy in the U.S. He received a PhD in politics from Princeton, an M.Lit. in politics from Oxford, an M.A. in politics from Princeton, and an M.Sc. in the history of political thought from the London School of Economics. And if you'll permit me a personal note, I have very fond memories of Stephen Macedo. In one of my more helpless moments as a young man, I had to submit to an orals committee in order to graduate from college. And I recall 4 very forbidding professors asking me a series of questions. And as I droned on and on trying to answer these questions, I recall only one of these professors actually stayed awake for the 2 hours of that helpless period in my life, and that was Stephen Macedo, who not only stayed awake, but engaged me very persistently, but also very, very graciously. And he's engaged me very graciously ever since. So I'm very grateful to you, Stephen. We look forward to welcoming you and hearing you. Thank you.
Now it's my turn to put Tim to sleep. I'll try not to. Look, I'm delighted to come here, delighted to have this opportunity. I'm a great admirer of this center and Tom and Tim, and I've used Nicholas's work in class many times and have mentioned him in print a number of times, and I admire his work deeply while disagreeing with it a bit. And it will remain to be seen how significant our disagreement is for practical questions we face involving the boundary between religious freedom and legitimate public policy. But I imagine we'll get to some of those questions later on. So I am going to respond to the paper that was circulated, and in particular the remarks towards the end, which are the parts I disagree with. Nicholas argues, and we heard some of this, that there's a natural right to religious freedom, also a human right to religious freedom. I have no problems with those broad assertions. I think his account of human capacities that underlie the religious temperament and religious liberty are very insightful and very useful. I don't have any problem with talk about natural rights, obviously. I sometimes worry that in practice it can lead to a kind of false confidence in particular claims. But nevertheless, I have no problems with the way that Nicholas lays this out. He also correctly notes, and I like the way he puts this very much, that the precise shape of our civil or constitutional rights vary quite a lot from one country to another, whether these rights are rights to religious freedom or speech or what have you. The Europeans call this a margin of discretion, and I like the way that Nicholas puts it in his paper, and I quote, "The various contours of the civil right to freedom of religion are all to be understood as positivizings of the natural right to freedom of religion. Each particular contour of the civil right to freedom of religion is the articulated inscription into law, the positivizing of the natural right to freedom of religion." That's fine. All natural rights that we have prior to government are bound to be vague in their contours, open to disputation, requiring balancing with other values in practice. And the unclarity of natural rights is among the things that makes government necessary. The capacity of shared legitimate political institutions to authoritatively specify the contours of our fundamental rights, at least to some degree, obviously subject to ongoing disputation, but to give our equal basic rights shape and definiteness is one of the great achievements of government, one of the great achievements of liberal democratic government in particular. And it's a project that all citizens share in necessarily and ought to participate in. Because they're important disputes. Now, I'm going to just skip over this. I like the fact that Nicholas says, and Tom said it in his introduction as well, that if we understand the religious temperament properly, then we should also understand that religious freedom extends equally to those whose worldviews do not include a God or a supreme being. Ronald Dworkin has just published a book posthumously, Religion Without God. Mentions Richard Dawkins and Daniel Dennett. We might add John Dewey. So I agree with very, very much in the first two-thirds of the paper, and then it's in the last third where I have some issues, but I wonder how radical they are. But in any case, my disagreements concern to some degree one of the four ways in which he thinks some people, excuse me, thinks that religion must shape up, and indeed it's the Rawlsian view that I tend to be more sympathetic with. And this is, in a way, he regards it as the least objectionable of these four views that he lays out towards the end of the paper. So let me just say a word about it. Rawls's idea, and I think Nicholas stated it pretty well, and I don't think it's just Rawls's idea, he just happens to have elaborated it, but it seems to me the norm is quite discernible in our political and constitutional practice, and it's stated by Supreme Court justices and others quite independently of Rawls, and I'll get to that. But it is that citizens in a diverse democracy have an obligation to one another when deciding important political questions, including the shape and contours of these basic rights, to cite reasons and evidence for the positions they support that are public, that can be shared in public, reasons and evidence whose force doesn't depend on accepting one particular religious worldview or even a particular philosophical worldview. We should draw on the shared ideals of our common political and constitutional tradition, look for ground that we can share. And the way that Rawls has elaborated it, of course, he says citizens are free to cite reasons that come from their religious perspectives, but they ought to, as well, cite reasons that can be shared by those who don't share their religious perspective. Now, when I've explained this to people sort of who are non-academics, the typical response has been, well, that's a completely anodyne idea. Who could disagree with that? But we do have some disagreement with it here, but again, even Nicholas's disagreement is not particularly radical. To appeal to common ground, the reasons and evidence that we cite might in principle reasonably regarded as weighty or good reasons by those who are not members of my church or my sect, because I'm making law for a political community of many sects and many churches. Now, Nicholas is concerned that there are people in our political community that don't share these principles, and he's concerned that Rawlsians and others require that they shape up in a way that's inappropriate. So I think he quoted his own remark, in liberal democracies, there are religious people who affirm liberal democracy. So he's suggesting that they have reasonable public views, but they're not in the habit of debating and deciding political issues on the basis of reasons drawn from public reasons. They believe that they should debate and decide on the basis of reasons drawn from their own particular religion. They don't know how to appeal to public reason, he says. Satisfying the Rawlsian injunction requires that they shape up, and he disagrees with that. He did add, and I don't think it was in the paper, that they will cite non-normative factual knowledge. So they agree at least that they ought to look for factual knowledge that is public in the right sort of way, but their normative beliefs, their ethical beliefs, I guess, that shape their political convictions are drawn entirely from their religious beliefs, and they do not wish to go beyond that. Now, look, one thing about these citizens is that they may quite excellently exemplify many other political virtues. It seems to me that they don't exemplify one, which is being concerned whether those outside their church also have good reasons to support the positions they advance, but if they're engaged in a liberal democratic agenda, as Nicholas hypothesizes, fighting for civil rights, fighting for the rights of the poor, well, my gosh, they're doing excellent work in all sorts of ways. And if their political positions, in fact, can be justified by public reasons, it just turns out that they're not interested in talking about them, then I don't think we're going to have a great objection here. The problem tends to develop when people operate from purely religious premises and their conclusions, their positions are one that we can't come up with good public reasons for. I think that's when the problem arises. So let me say, I think that such citizens, in general, though only quite mildly, if it turns out they're supporting a liberal democratic agenda, are violating one important norm of citizenship, which is important in a diverse community, that we should look for common ground. It's not enough to say, the Bible says it, I believe it, and that's the end of it. It's uncivil. It violates a norm of citizenship in a diverse democracy. I mean, happily, there are, it seems to me, very few people that argue in that way in our politics, especially in our national politics. For one thing, it would be quite ineffective because we disagree about religion. We disagree in our interpretations of the Bible, if that's our holy book. And that's the important thing. It's not that there are too many irreligious people out there. It's that there's religious diversity. So we look for grounds that people with diverse religious views can share. I'll come back to that point in a minute. I think Nicholas and I partly just disagree about whether this is a norm that's widely shared. Okay, he mentioned several other views of people who think that religion should shape up, and I agree with him in rejecting those. Rorty's view that religion is dangerous unless it's fully privatized, that seems to me quite an eccentric view that few people espouse, and I think it's an unreasonable view. The view of John Hicks, which is interesting, which I interpret to be that religion itself should be non-exclusive, that from a religious point of view, we should regard different religions as different paths to a single ultimate truth, I think seems to be the view, that all religions are the same in the eyes of God, not just in the eyes of the state. That's a view that others have advocated too. It sounds like Hinduism in some ways, to sort of incorporate various religious perspectives into one common perspective. But that's not the liberal idea. The liberal idea sticks to insisting that in the public realm, we ought to practice these public virtues, and it's up to people to sort of work out how they bring that into alignment with their own religious views in their own way. And finally, the idea that Nicholas associates with Derrida and Kant, that religion should be emptied of determinate content. So these are all religious claims about religion, and the interest, I think, of liberal Democrats is in saying something about the public realm, not prescribing to religious people how it is they should go about reconstructing their religion in the face of religious diversity. But there are a couple of things worth noting, and I think we agree here. In the remarks in his paper, I worried that he was against sort of a general project of shaping up in general, but in fact, he believes that religion needs to shape up for liberal democracy in a variety of ways, and I also agree with that. Religions that themselves are intolerant, that refuse to accord equal rights to people with different religious beliefs, that refuse to treat equally citizens of other faiths, that would use the state to disadvantage, harass, or persecute people who dissent from the official religious view, those religions do need to shape up, and they need to shape up precisely because we believe in religious freedom and we think it's a basic right. So Nicholas and I agree, I guess, that in order for religious freedom to be recognized, there are religions, certainly religions in the past, that needed to shape up, and there are religions now that need to shape up. So we agree on a lot of shaping up for the sake of liberal democracy. When John Locke wrote his letter concerning toleration anonymously, arguing that the first duty of Christians was to practice meekness and toleration with those they disagree with, he was not expressing the general view. There were many who thought it was both a religious duty and politically prudent to impose conformity. So shaping up is necessary. Here at Georgetown, I might observe, and I think as many of you know, the sort of shaping up that came with Vatican II, in effect, in its Declaration of Religious Freedom. John Courtney Murray was mentioned before. Samuel Huntington's important book, The Third Wave, argues that the third wave of democratization is a Catholic wave. Once the Catholic Church shaped up, Catholic countries shaped up and became more democratic, less authoritarian. Catholicism went from being associated with anti-democratic authoritarian regimes to pro-democratic regimes, post-Portugal and Spain and Latin America and so on, revolutions there. So shaping up is a very important agenda, but it seems to me that we want to emphasize from a political standpoint the norms that we can reasonably expect all of us to comply with, norms of equal freedom, and we leave it to religious people to work out in their own ways how they go about integrating those views with their religious perspectives. But there are many religions that will need to do some work, some religions now that will need to do some work in order to do that. But Nicholas's objection and the point on which we disagree is a little different. And as he said in his remarks, it represents the point of view of the person who has an integralist view. It's his integralist objection. The person who believes that he or she should comport themselves on the basis of their religious convictions in the public realm when deciding important questions, including the shape and contours of basic rights. That does seem to me to present problems, but obviously such people, as he says, are free, in a society to exercise their political rights and so on. Now, one thing that Nicholas says is that he sees no chance of citizens in general conforming to the Rawlsian norm. And I just want to suggest against Nicholas that we do, in fact, largely do so, and it's a good thing. And I'll cite one set of examples that I've been looking at and working on. I'm actually working on a book on the future of marriage, which is to say marriage after gay marriage, why a two-person status relation in law of marriage, why not contract, why not polygamy, polyamory. In part, it's about responding to the various slippery slope arguments that have been put forth by conservatives. If we have same-sex marriage, we're going to have polygamy, we're going to have this, that, and the other thing, probably have marriage privatization. It seems to me monogamy makes a huge amount of sense, makes just as much sense post-gay marriage as it makes pre-gay marriage. And indeed, I want to argue that monogamy is properly regarded as part of the basic structure of a liberal democratic society because it promotes an equal opportunity to enjoy the great good of family life. Polygamy in its historical forms rather than in the fantasies of academics has involved vast inequalities and greater social conflict and so on. So anyway, I won't go there. But if we look at the discussion in this country, the conflict around gay rights, privacy rights, rights to sexual freedom in the first instance, and the current debate about marriage, it's deeply and systematically and consistently informed by norms of public reasoning. I mean, the reason is everyone knows that claims about sin are in the background, that religious teachings have shaped people's attitudes towards sex and marriage, and conservatives themselves have been embarrassed by some of the arguments that have been put forward in some authoritative institutions to deny equal rights to gays. This was strongly exhibited in the case of Bowers versus Hardwick 27 years ago, when the Supreme Court upheld Georgia's criminal sodomy statute as applied to gays. If you look at the opinions for a slim majority in the court at that time, they're not strong arguments. There's practically no argument at all. There's bald assertion. So Justice White, writing in 1986, simply declared that homosexual sodomy, bears no resemblance to the court's previous privacy cases. Gay sex has no connection, didn't say gay sex, but that's what I'm saying, has no connection with family marriage or procreation. To claim otherwise is at best facetious. In effect, the argument was the people of Georgia believe that this is wrong. Decent people have always thought it was wrong, and that's enough. We don't need any further reasons. Justice Warren Burger wrote separately to emphasize the long tradition of condemnation of homosexual sodomy, firmly rooted, he said, in Judeo-Christian ethics, capital crime in Roman law, an infamous crime against nature, not fit to be named, so on and so forth. I mean, the tone suggests how dare anyone actually question this. And in his dissent, Justice Blackmun was equally pointed and said, quoting Justice Holmes, "It's revolting to have no better reason for a rule of law than so it was laid down in the time of Henry IV. And it's still more revolting if the rule simply persists from blind imitation of the past. Before Georgia can prosecute its citizens for making choices about the most intimate aspects of their lives, it must do more than assert that the choice they have made is an abominable crime not fit to be named among Christians." So many conservatives may have found the result in Bowers acceptable, but I think many were embarrassed by the court's reasoning or lack of reasoning. John Finnis, recognized that embarrassment, and I quote, makes most people more than usually inarticulate with respect to homosexuality. And he insisted that public policies must be based on reasons, not mere emotions, prejudices, and biases. Good for him. And he's participated in that discussion, and I've been very delighted and honored to participate with him in that discussion. And he would have added some variation on the Rawlsian claim that the reasons ought to be not religious and doctrinal reasons, but reasons that could be presented as a matter of public philosophy, new natural law, premises that can be accepted by people with different religious faiths. So John Finnis, my colleague Robert George, and others in the natural law tradition have advanced public arguments, including in a recent book by Sharif Jerjes, Ryan Anderson, and Robert George, What is Marriage? A very philosophically sophisticated argument. And that's good. That's good. So it seems to me that this norm of public reasoning is common. It's widely accepted. It's accepted oftentimes on both sides of very difficult political controversies. Some disagreement about exactly how it applies. The dependence of the natural law argument on certain metaphysical premises may be an issue. But the need to cite evidence has been widely asserted, not just in the courts, though of course it has been asserted there, but in legislatures, television talk shows. I can remember hearing an episode of The Factor with Bill O'Reilly. Not one would think of as a Rawlsian necessarily, but you know, having a discussion, kind of a libertarian though on some of these issues, having a discussion about same-sex marriage with a conservative, and he's asking, "Sir, what's the harm in same-sex marriage?" And a bit of inarticulateness, and "Sir, what's the harm? You're going to have to do better than that." So trying to find reasons and evidence that are common to shape these matters. Not surprisingly, when Bowers was overturned in 2003 by Justice Kennedy, he observed that many people condemn same-sex relations based on religious and ethical ideals to which they aspire and which thus determine the course of their lives. The issue is whether the majority may use the power of the state to enforce these views on the whole society. That's correct. And if there are religious people who don't recognize the essentially public nature of that question, and that they must do more than cite their particular religious convictions when shaping the rights of all, then my assertion is simply that they are violating a fundamental norm of citizenship. They may be very good in other respects. So with respect to marriage, obviously, the debate has returned over and over to certain matters of obvious public interest, the well-being of children being central to the debate. Everyone acknowledges that as a reasonable public concern, central to the reservations, past opposition of David Blankenhorn and others. And the argument has been advanced and responded to. Other arguments, again, have been public arguments, slippery slope arguments of the sort that I already mentioned. Same-sex marriage will lead to polygamy, incest, and bestiality. Those things all do involve real public harm. So the arguments are at least on the right track. They just don't turn out to be very good. And then, of course, the arguments of the new natural law, which are advanced based on philosophical and ethical claims, not religious premises. Part of a wider sexual morality, which I don't need to explain here at Georgetown probably, but in which marriage is necessarily the relationship of one man and woman, because in order to be the kind of comprehensive union that marriage is, it must be consummated by sexual acts that have procreative significance, and so on. The position, in a way, is not that hard to explain. I believe what's hard to convey is its persuasiveness to those who don't share the wider perfectionist sexual ethic. It's not a crazy sexual ethic, and I don't despise it or scorn it at all. It just seems to me that it's not one that it's reasonable to expect citizens with a wide variety of views to share. Interestingly, when the argument was sidled up to by the attorney defending Proposition 8 in California, defending marriage as one man and one woman, and then again in the Supreme Court, Charles Cooper, he was asked about this, what the harm of gay marriage is, same-sex marriage. In California, his frank response was, "Your Honor, I don't know." In the Supreme Court, he did attempt to advance the marriage as procreation argument, and it led to an exchange with Justice Kagan that Scalia joined in. You may have heard this on the radio. Justice Kagan asked Charles Cooper if the state's interest is in keeping marriage focused on procreation. Would it be okay if the state said that people over the age of 55 can't marry? Well, Cooper said both parties to the marriage may not be infertile. Laughter in the courtroom. Justice Kagan, I can assure you, if both the man and the woman are over 55, there are not a lot of children coming out of that marriage. More laughter. Scalia joins in. Well, I suppose you could have a questionnaire at the marriage desk when people come in. Are you fertile or are you not fertile? More laughter. Cooper comes back. Well, one of the parties may be fertile, and Scalia can't resist and says for some reason Strom Thurmond was. And he honestly said that. But in any case, this was, an attempt to try to articulate the marriage as must involve procreation and gender complementarity and so on. Not very successfully, and obviously it could be done much better. But let me just say this about this argument and closing. I recently came across an excellent piece reflecting on the problems faced by the new natural law arguments considered as public arguments. And by Paul Griffiths, who's a Catholic theologian at Duke. I've never met him, and he never mentions Rawls, but it seems to me a very sensible point of the natural law orthodoxy. He says, I think the orthodoxy is true. I think the arguments are valid, and it would be better if everyone thought so. But there are not, as a matter of fact, arguments available that do or should convince those who do not hold that orthodox view, whether Catholic or non-Catholic, that they should. The lack of such arguments, I'll call them public arguments, is empirically obvious. The premises are rationally disputable. The truth about none of these things is obvious or self-evident, which is among the reasons that thoughtful, well-meaning people differ so profoundly about them. That seems to me a very sensible remark by someone who accepts the Catholic natural law argument. On the other hand, the fairness arguments for including gays in marriage are very straightforward and have been articulated by philosophers like Alec Baldwin. There are. We'll just quote a brief part. There are people who are married in the eyes of the state, enjoying all of the legal benefits, who have no intention of having children. They seek only companionship and all the entitlements that come with marriage, sex, joy, partnering, caring, and so on. All of that's theirs, even though they'll never bear children, and willfully so. And if the state says they are free to, why aren't gay couples as well? So in any case, at every step along the way, there's been an articulate and self-conscious concern about the shape of the reasons that are being cited. If you look back at the debates in Congress in the mid-1990s over the Defense of Marriage Act, exchanges between Henry Hyde and Barney Frank and so on, what's the harm? How is it going to harm children and so on? So it seems to me that we do have a general norm of public reasoning and that it's a good thing. Let me just quote one other thing by David Moats, who won a Pulitzer Prize. He was the editorial, maybe still the editorial editor of the Rutland Herald in Vermont, and he was there for the long debates around civil unions in Vermont. And looking back, he reports this: I had not read John Rawls at the time, but the editorials I wrote on the question of private morality and public justice reflected a Rawlsian conception of democracy. And the way he put it is this: it's a bit homespun, but I kind of like it. The village green of a typical Vermont town was emblematic of my view. The green might be surrounded by a congregational church, an Episcopal church, a Unitarian church, a Catholic church, a public library, and a tavern. Citizens would enter each place, for their own personal reasons, and they would be free to fashion their own moral codes from what they learned inside. But when it came time to develop public policy, the citizens would have to emerge onto the village green and meet together to pass laws that the majority could support. No individual sect would have the authority to force its moral views on the others. Somehow, the separate groups would have to find common ground on which to act. What Rawls calls a comprehensive view of morality, as embodied in religion, philosophy, or some other moral teaching, is not the business of government. And I agree. Let me just mention one other quote. This is much briefer. It's a book called The Democratic Virtues of the Christian Right by John Shields. I mistook the title as The Deliberative Virtues of the Christian Right. But let me just say, it's an empirical study of Christian right activist groups, and actually a student of mine at Princeton did something very similar, looking at Focus on the Family in Colorado. But he says this: I argue that the vast majority, this is the point of the book, I argue that the vast majority of Christian right leaders have long labored to inculcate deliberative norms in their rank and file activists, and especially the practice of civility and respect, the cultivation of real dialogue by listening and asking questions, the rejection of appeals to theology, and the practice of careful moral reasoning. And he goes on later in the paragraph, page 2, to say, Christian apologetic organizations teach thousands of citizens every year to make philosophical arguments rather than scriptural ones because Paul instructs Christians to give reasons for their beliefs. From this perspective, then, Jesus Christ was not a belligerent moralist. Thus, ignoring deliberative norms is not merely impolitic, it is also considered to be unfaithful. And that's true. That's also what my student Nick Klemp found looking at Focus on the Family in Colorado, that they recognize that speaking to the wider polity about public policy issues, it's prudentially important to cite widespread reasons and evidence. You're trying to build a political coalition after all. But they also believe that there are religious norms that support these norms of public reasoning. So all of this, it seems to me, represents a good way for citizens to participate. Citizens with diverse religious and philosophical perspectives in a process of common deliberation, which is seeking common ground on the basis of which to shape the contours of our fundamental rights. Good reasons that we can share. To transform, in effect, different accounts of what people believe our natural rights are into shared authoritative civil or constitutional rights. It ought to be a common conversation, seeking common ground on which to shape our basic common rights. I have a hard time seeing why Nicholas thinks it's unimportant, at least. I think he thinks it is important, but I think he thinks there are people who opt out of it without in a way that's entirely excusable. I don't know what I want to say about excuses, but he made a remark towards the end, wouldn't a Rawlsian say that these people are entirely justified in what they're doing if they consciously believe that what they're doing is required by their religion? Well, yes, I would say that they're subjectively justified, as it were, but objectively wrong. I don't believe that religion, properly understood, requires that sort of comportment in politics. I tend to agree more with John Shields. So you can be subjectively justified but objectively wrong, and those citizens are objectively wrong about the virtues of democratic citizenship. So this seems to me to be, I think a pretty minor point of disagreement, and none of this I think is going to help us that much with difficult issues that face us nowadays as we think about particular issues involving religious freedom and conflicts involving public policy, such as whether it's legitimate or not for the Health and Human Services to mandate health coverage to employees that includes contraceptive services, the mandate as applied to for-profit businesses, religious institutions and faith-based not-for-profits having been exempted, I believe. Is it an infringement on the free exercise rights of the owners of companies who disapprove of contraception to be required to provide them by the government? I don't see how notions of natural rights can help us with that. These sorts of questions are too implicated in complicated institutional contexts. I think Nicholas and I will probably agree with that. And I would certainly prefer that when we have these conversations, we, as I suggested and as John Rawls has suggested, do it on the basis of common grounds, and even this, let me just say this in concluding, that one of the common grounds has to be a mutual acknowledgement that the shape of our free exercise rights is part of a general scheme of equal rights for people of different religious faiths. And in a way, that's why people need to step out of their particular religious frameworks to see that there are people with other religious faiths in part who have equal rights, and that it's reasonable for them to expect that the grounds that are cited by the state to shape their equal rights, as well as one's own, are grounds that they can share. So anyway, that's all I have to say.